Hello guys, let's begin with this table because in the last video that I had uploaded, we talked about the conflict of laws and how it arises when a foreign element is involved. Okay, it can be one foreign element or more than one as well, which I tried to explain at my best by taking few examples in the last lecture. Uh, this is the main point of difference between the two, or what majorly they talk about. Both are the international streams of law, but one is public, the other is private. Private is related to the disputes of citizens across nations, and public basically is intergovernmental, that is between the governments of different nations, right? That is the main thing which you can understand to differentiate between these two terms. Public international law is a set of rules that governs intercourse between nations. Intercourse is trade and commerce, which is very well obvious because of the fact that any country or any person is not self-sufficient, right? We are interdependent upon each other as a nation also, for few things like import export of few commodities or articles do happen on a daily basis. And if that import and export is regarding a particular nation, then of course it will be in tons, right? Such huge quantities. So the intercourse or trade and commerce basically between nations through determining the rights and obligations of governments of nations. As I told you, it is the relationship or the law which governs the governments of different nations. Okay, and private comprises of certain rules, regulations. Law is what? Rules. Law is a set of rules. So that part of both of these definitions, set of rules, that is because of the term law, established or agreed upon by private citizens from different nations who enter into transactions, and that would govern them if a dispute were to arise. So private international law means the nations, see, citizens cannot themselves agree on behalf of their nations with the government of another nation, right? मैं जाकर अभी ऑस्ट्रेलिया के साथ कोई कॉन्ट्रैक्ट नहीं कर सकती एज अ होल कि अगर मेरा ये डिस्प्यूट अराइज होगा तो तुम ये लॉ अप्लाई कर देना, right? But basically what this means is that if the two parties are entering into the contract and they know that they belong to two different nations, yeah, there is some foreign element involved. One of the few examples that I gave you in the last lecture video, suppose if I take the example A and B. A is of India, B is of USA, and they are entering into the contract in UK. So they themselves know that one party is of India, another party is of USA, and the contract is entered into UK. So there are these foreign elements involved, right? So by themselves, these two parties by themselves, they can agree in this contract itself that if any dispute arises in future, then we would be governed by the laws of UK, because the contract is entered into in that country. So wherever the contract is made from, that country will have the jurisdiction. Okay, so अगर ऐसा कुछ इन दो पार्टीज़ के बीच में डिसाइड हुआ है, दैट मीन्स दे आर स्किपिंग द जुरिस्डिक्शन ऑफ इंडिया एंड यूएसए बाय देमसेल्व्स and adopting to the laws of another nation. So this is what it means when we say established or agreed upon by private citizens from different nations, right? Enter into transactions. See, contract is what? A transaction, a business that would govern them if a dispute arises. So it is very common thing that two people are there may be some disagreements or some point of difference opinion, their perspectives may be different to a particular thing. So it is likely that a dispute may arise between any two set of people, right? So in that situation, they very well know they have some foreign elements between them, so they can themselves decide in their contract itself by writing a clause, or they may make a different contract to that effect जिसमें सिर्फ ये बात लिखी होगी लाइक एक मेन अग्रीमेंट होगा जिसमें उनका जो भी ट्रेड या ट्रांजैक्शन बिजनेस की डिटेल्स हैं वो होंगी, एंड देयर मे बी अनदर अग्रीमेंट जो सिर्फ जुरिस्डिक्शन के लिए अग्रीमेंट बनाया होगा उन्होंने, ठीक है, और दे में include that jurisdiction clause in the main agreement itself. So either ways they can do. Okay, I hope this is clear. ये तो सिंपल ही है. Out of these two, the confusing one is this: international bodies harmonizing private laws of different countries. See, why we need to harmonize? Because of the foreign elements. ऐसे ही foreign elements वाले cases बहुत ज़्यादा होते हैं, because as we know countries के बीच में import, export and all that stuff do happen on daily basis. तो फॉरेन एलिमेंट तो इंक्लूड होगा ही होगा. और आजकल तो ब्रेन ड्रेन भी कितना हो रहा है. इंडियन पार्टीज इन वेल गुड हैंडसम in jobs they are going to America, right, because of their companies company have transferred them to America, right, to represent or to work on their behalf, right. So अब इंडियंस अगर अमेरिका में जाकर जॉब कर रहे हैं, वहाँ पर कुछ डिस्प्यूट अराइज हुआ, तो जाहिर सी बात है जो कोर्ट वहाँ पर अवेलेबल है दैट विल बी द कोर्ट ऑफ फर्स्ट इंस्टेंस. वो सबसे पहले तो उसी कोर्ट में जाकर अपने डिस्प्यूट का रेजोल्यूशन मांगेंगे, राइट. बाद में वो कहीं अगर हुआ कि नहीं ये वाला कोर्ट हमको सही से नहीं दे रहा, या हमको इंडिया जाना है, सो इंडिया जाने में भी मतलब वापस आने में बहुत टाइम लगेगा. सो एट द फर्स्ट दे विल सीक जस्टिस और रेजोल्यूशन ऑफ दिस देयर डिस्प्यूट in the court which is nearby, right, and that would also have jurisdiction because of the place where the cause of action has arisen. जहाँ पर dispute arise हुआ है यानी कि cause of action arise हुआ है, और by lieu of cause of action being arisen at that place, उस कोर्ट का जुरिस्डिक्शन अपने आप आ जाएगा. जैसे मैंने बोला कि कॉन्ट्रैक्ट वॉज ब्रीच्ड इन यूके, तो यूके कोर्ट हैज़ जुरिस्डिक्शन बिकॉज कॉज ऑफ एक्शन हैज़ अराइज देयर, राइट. सो अब इसीलिए हार्मोनाइजिंग करने की ज़रूरत है ताकि हमें पता चले कि एक मतलब एक कॉमन सेट ऑफ यूनिफॉर्म सेट ऑफ रूल बन जाए कि अगर कॉन्ट्रैक्ट ब्रीच हुआ है तो कौन सा कंट्री का लॉ अप्लाई होगा, कौन से कंट्री को हम जुरिस्डिक्शन देंगे, एंड दैट विल अप्लाई यूनिफॉर्मली टू ऑल द नेशंस थ्रू आउट द वर्ल्ड. जैसे अभी हमें पता है कि अगर कोई इमूवेबल प्रॉपर्टी से रिलेटेड ट्रांजैक्शन है, सेल, मॉर्टगेज, गिफ्ट, व्हाटएवर, तो हमें रेफ़र करना है ट्रांसफ़र ऑफ प्रॉपर्टी एक्ट, TPA, राइट. अगर कोई क्राइम किसी ने किया है तो हमें रेफ़र करना है इंडियन पीनल कोड या रिसेंटली द अमेंडेड वन भारतीय न्याय संहिता, BNS, राइट. So we need harmonizing so that by conventions or some accepted rules throughout the world or in major countries वी नो कि हमें इस पर्टिकुलर मैटर पे कौन सा लॉ अप्लाई करना है या किस कंट्री के डोमेस्टिक लॉ के हिसाब से चलना है, राइट. सो इन एनी केस इफ़ देयर इज़ अ फॉरेन एलिमेंट इन्वॉल्व्ड, हर एक कंट्री का अपना डोमेस्टिक लॉ, सिविल लॉ अलग है, क्रिमिनल लॉ फॉर दैट मैटर इज़ ऑल्सो डिफरेंट, राइट. सो हम किस पर्टिकुलर कंट्री का लॉ किस सिचुएशन में अप्लाई करें उसके लिए कुछ सर्टेन पैरामीटर्स हैं, जैसे मैंने बताया था फॉर एग्जांपल ऑफ मैरिज, राइट. अकॉर्डिंग टू द लॉज ऑफ विच एवर कंट्री द सेरेमनीज ऑफ मैरिज हैव टेकन प्लेस, that particular law would be applicable. Yeah, where the marriage has taken place, it will be applicable, right. So such are the harmonizing principles. The bodies which work for the harmonization are Hague Conference on PIL, convened by the government of Netherlands, originates in 1893, focus on developing conventions on a wide array of aspects of private law. Array means variety of a wide range of aspects of private international law. It focuses on making the conventions, and it is made by the government of Netherlands in 1893. International Center on Settlement of Investment Disputes, International Institute for Unification of Private Law. Investment disputes can be related to business transactions where like what is business? You are investing on some product or some capital, right? Then unification of private law. Unification means to make it a unit. Unit is one. United Nations Commission for International Trade Law, that is UNICITRAL, works towards developing model laws and guides regarding international trade, commercial laws, including UNICITRAL arbitration rules and so on. And on the basis of the India's Arbitration Act is based on UNICITRAL model of arbitration rules only. Okay, so the United Nations Commission for International Trade Law, it basically provides some model laws or guides or some principles that any country's law should have these basic principles, or they should make this particular convention or law as देयर गाइड. उसको अपना गाइड समझकर या उस पर बेस करके अपनी कंट्री का लॉ बनाएं. ठीक है, जैसे हम क्वेश्चंस के, जैसे आपके बोर्ड में जो क्वेश्चन आते हैं उसके कुछ मॉडल आंसर्स दिए जाते हैं, राइट. सो व्हाट इज़ द पर्पस ऑफ दोज मॉडल आंसर्स? It serves as a guide that what all should you include in an answer to a particular question, right? Similarly, the model laws also serve as the base for different countries to make their laws on. Some of the international conventions, model laws in sphere of private international law that gained more traction in recent times are United Nations Convention on Contracts for Sale of International Goods. So international goods is what? Import and export of goods, right? Suppose if those Chinese toys or Chinese articles that come in India, those are what? International goods, because they are not something which have been manufactured in our country, right? So, and whatever import and export is taking place, that is also on the basis of agreement or contract of business between two nations, right? Even for a simple transaction within India, there are different contracts that people enter into, right? And contract in itself is called a commercial or business transaction. So similarly, if two nations or two or more nations are doing some import or export, or they are selling some goods to another country, then for that also they enter into contracts, right? Basic cheez hai. It is also called Vienna Convention on Sale of Goods. Goods is any article, any immovable article basically, that is sold off. And what is the meaning of sale? Whenever you see this word sale, that means the ownership of that particular product, article or thing is being transferred from one person to another. Uska owner badal raha hai. Multilateral treaty which provides options for avoiding choice of law issues by providing a framework of accepted substantive rules with respect to contract disputes. Since it is related to contract, so its main area of concern is the contract disputes. Okay. And multilateral treaty means treaty is something we have done what is a treaty in the sources of law chapter, right? So I think you know multilateral means many nations are a part of it and provides options so that they can avoid the choice of law. Choice of law, see, for a person who is an Indian citizen, dispute has arising in India also, then you have no choice. ठीक है, जो भी इंडिया के सेंट्रल या स्टेट के जो भी लॉज होंगे ऑन दैट पर्टिकुलर इशू विच आर अट्रैक्टेड, दे विल बी अप्लाइड. आप उस पर चॉइस नहीं कर सकते कि नहीं ये TPA मत लगाओ, इसमें मतलब सेल्स ऑफ गुड्स एक्ट लगा दो, या दिस इज़ नॉट अ क्राइम, आप इसको टॉर्ट्स में डालो, आप इसको IPC में मत डालो या BNS में मत डालो. आपके हिसाब से चीज़ें नहीं होती हैं. Because as a citizen of India, you are bound to follow the domestic rules of this country. Or if residing in a particular state, which of course you will be, so आपको उस अगर state के कुछ amendments होंगे to the central laws, या state अपने भी कुछ laws बनाता है, right? तो आपको उसको भी follow करना पड़ेगा. As and whatever laws are being applicable as per the situation or the matter in dispute, right? You have no choice in that. choice of law comes into picture when again domestic law of two or more nations are involved, or there is a foreign element to say. Having said that, if you remember the example that I gave you in the previous lecture, if you don't remember, you can go out to the previous video and check it out, because I'm not going to explain it again and again, and I will take the reference of it also as far as private international law is concerned. So choice of law comes into being when I said that two people are of a different nation, they have entered into contract in a different nation, right, and the contract was breached in another third nation. So now 3 countries are involved. ठीक है, हो सकता है that people in their contract, if you remember, we have done that in the contract itself they can insert a clause that they will be accepting the jurisdiction of which nation if a dispute arises in future, right? So that is the choice of law कि आप तीनों कंट्रीज़ के लॉ एप्लीकेबल हो सकते हैं यहाँ पर ड्यू टू डिफरेंट प्रिंसिपल्स, या ड्यू टू द प्रिंसिपल ऑफ डोमेस्टिक लॉ इन दैट पर्टिकुलर नेशन, किसी ना किसी तरह से तीनों कंट्री के लॉ आप पर एप्लीकेबल हो सकते हैं. तो अब आप चूज़ कर रहे हैं दैट यू विल बी सब्जेक्टिंग योर सेल्फ to the law or to jurisdiction of which country. Okay, so that is choice. That's where this choice comes into picture. And private international law का दूसरा नाम ही choice of law है. ठीक है, so it provides the framework of substantive rules. Substantive rules means, suppose I say 5 plus 5 is equal to 10. This is something which is substantive. फॉर एग्ज़ाम्पल, यू कैन नॉट चेंज इट, राइट, ये फैक्ट है. तो कुछ रूल्स होते हैं जो आपको प्रोसीजर नहीं बताते कि चीज़ कैसे करनी है. फॉर एग्ज़ाम्पल, इंडियन कॉन्ट्रैक्ट एक्ट इज़ अ सब्सटैंटिव लॉ. ये आपको पर्टिकुलर सिचुएशन में सपोज अगर कोई ब्रीच हुआ है, क्या रेमेडी है, कितना कॉम्पनसेशन देना है, वो सब बातें बताएगा. बट सिविल प्रोसीडिंग्स कैसे कंडक्ट होंगी इन अ कोर्ट ऑफ लॉ, वो आपको नहीं बताता है. ये रेमेडी देनी तो है, बट कैसे देंगे, क्या सारे चीज़ों को कंसिडर करके, सर्कमस्टांसेस, एविडेंस, मटेरियल फैक्ट्स या विटनेसेस की टेस्टिमनी, कॉन्ट्रैक्ट देखेंगे, डीड देखेंगे, क्या सब कुछ करेंगे, दैट ऑल प्रोसीजर इज़ नॉट प्रोवाइडेड इन इट, राइट. सो दैट मीन्स इट इज़ नॉट अ प्रोसीजरल लॉ. प्रोसीजरल लॉ इज समथिंग विच टेल्स यू द प्रोसीजर, एंड सब्सटैंटिव लॉ इज समथिंग जो आपको सब्सटेंस बताएगा कि ये सिचुएशन है, ये रेमेडी है. ठीक है, सो इट इज़ द सब्सटैंटिव रूल्स एंड विच इज़ ऑल्सो एक्सेप्टेड बाय द नेशंस, बिकॉज इट इज़ अ ट्रीटी, मल्टीलैटरल ट्रीटी दैट टू. सो इट इज़ एक्सेप्टेड बाय द नेशंस ऑल्सो, एंड दैट होल फ्रेमवर्क, जैसे मैंने बोला कि कॉन्ट्रैक्ट ब्रीच हुआ है तो इस कंट्री का लगेगा, मैरिज हुई है, मैरिज का डिस्प्यूट है जिसमें फॉरेन एलिमेंट है तो ये रूल लगेगा. सो दीज आर व्हाट द सब्सटैंटिव रूल्स ओनली. Okay, those were the examples that I gave you, and if you want to understand even a vague picture of private international law, तो आपको वो examples समझने होंगे अच्छे से. रिवाइंड करिए वीडियो को, बार बार सुनो और वो अपने आप समझ में आ जाएगा. Because I have not myself delved deeper into that so as to confuse you. Okay, so you just rewind it twice, thrice, or no matter n number of times, but just try to make that concept clear, a vague idea of it clear, because then only ये सारी जो आगे की चीज़ें हैं, choice of law कहाँ से आया, या dispute क्यों आ रहा है, foreign element क्या होता है, ये सारे terms का मतलब ही तब समझ में आएगा अगर वो examples clear हैं तो. Okay. It is considered one of the most influential documents in PIL and nowadays deemed to be incorporated into any otherwise applicable domestic laws unless expressly excluded. Which means that, right, this means that this is one of the most accepted documents, and it is also accepted in various domestic laws of the nations. Implicit होता है ये, ठीक है, unless expressly excluded. That means it is deemed to be incorporated means माना जाता है कि वो हर domestic law में automatically if a country has accepted it, that means उस कंट्री के डोमेस्टिक लॉ में वो ऑटोमेटिकली इन्वॉल्व्ड है, उस कंट्री ने उसको अडेप्ट कर लिया है, ये माना जाता है, ठीक है. एंड unless expressly excluded, unless the country mentions in any of its law which is related to the international disputes that हम इस convention को नहीं मानेंगे, unless it has expressly or explicitly stated that on clear terms and it has conveyed its clear intention that it is not going to follow this particular convention or commission, तब वो exclude होगा. Otherwise, because of this a legal fiction is created and it is deemed to be included. Legal fiction, ठीक है. Okay. Unilateral model of international commercial arbitration provided a framework for domestic laws on international arbitration and adopted by an increasing number of countries. India has also adopted it in 1996. Geneva Convention on Execution of Foreign Arbitral Awards and so on. Now arbitration is, I think we have done this, we have also done this in the family disputes chapter, wherein we were dealing with conciliation, right? Arbitration and conciliation both are two methods of alternative dispute resolution mechanism, right? And it means that the person is not going to a conventional court of law but out of court settlement कर रहे हैं, and deviating from that conventional way, they are themselves appointing a third neutral person as an arbitrator, right, who would listen to both the parties and then he or she will give the decision that would be the resolution of their disputes, right? That is called adjudication of the dispute by a third neutral party, arbitration, right? And that third neutral party is called arbitrator. The decision that he has given is called arbitral award, and it is as equivalent as a decree passed by a court of law, okay? And on this model law only the India's Arbitration Act is based, as I have already told you. And this is also adopted by, these are some model laws which are adopted by various nations of the world, or they have based their domestic laws on these model principles, okay? And India is also one of them. Now, what is the meaning of foreign arbitral awards? Arbitral award is basically, as I told you, the award which is given by the arbitrator, that is considered to be the resolution or adjudication of the dispute, okay? Now if it is foreign, that means again two or more nations are involved, or the parties or citizens of two or more nations are involved, right? So that adds the term or the element of foreign into it. Execution means जो भी award दिया गया है उसको enforce करना. अगर the court has said or an arbitrator has said that it is found correct that A has breached the contract and is liable to pay 10,000 rupees to B, okay? Because he is not ready to perform the contract, then whatever mental agony or financial loss has been incurred to B, for that A is to pay compensation of rupees 10,000 for suppose. So this is the decree or order or award passed by the court or arbitrator. Now इसको एग्जीक्यूट करवाने का मतलब है कि वो 10,000 रुपये ए बी को दे रहा है, ठीक? दैट इज़ द मीनिंग ऑफ एग्जीक्यूशन, कि हमने उस डिक्री को एग्जीक्यूट किया एंड उस एग्जीक्यूशन के तहत हमने उसको 10,000 रुपये दे दिए, विच वॉज सो ऑर्डर्ड. देन दिस इज सम क्लास एक्टिविटी दैट इज़ नॉट माई कंसर्न. Now we come on to sources of international law. A source of law within a domestic legal system is easier to determine. Within the domestic system, it is considered as something which is not too difficult a process. Means when domestic laws of a country are framed, we consider that it is not very difficult to determine the sources, because generally for domestic laws the international principles on that topic, area or subject, the international principles are the guide और मॉडल्स, ओके, और उसी पर बेस करके वो अपना डोमेस्टिक लॉज बना सकते हैं. या इफ़ देर इज़ अ पर्टिकुलर प्रॉब्लम विच इज़ प्रिवेलिंग इन द सोसाइटी ऑफ दैट नेशन, ठीक है, विच इज़ वेरी अर्जेंट टू बी एड्रेस्ड, हाई नीड, हाई टाइम ऑफ द आवर, राइट. सो इन दैट सिचुएशंस उस प्रॉब्लम को कैसे एड्रेस किया जाए, दे कैन लुक इनटू इफ़ द सेम प्रॉब्लम वॉज एग्जिस्टिंग इन एनी अदर नेशन, तो उन्होंने उसको कैसे डील किया, राइट, और वो उस तरह से बना सकते हैं. फॉर एग्जाम्पल, आवर इंडियन कॉन्स्टिट्यूशन इज़ ऑल्सो कॉल्ड a borrowed book because it has borrowed some principles from various nations across the world, right. So similarly here also that is known as that is to say that for a domestic law to be made, the sources or the process is not so difficult. We consider that it is not a difficult process because होता क्या है कि अगर जैसे सती प्रथा थी फॉर एग्जाम्पल, it had to be abolished. तो जब ये बात सोची गई होगी कि दिस इज़ समथिंग विच इज़ अ बैड और एविल प्रैक्टिस एंड इट हैज़ टू बी अबॉलिश्ड और देर हैज़ टू बी सम वे आउट ऑफ इट, तो क्या सोचा, अबॉलिश ही कर दो, ठीक है, और उसका एक एक्ट पास कर दो, राइट. सो आउट ऑफ दैट होल क्राउड और मे बी मैनी पीपल हैव रीच्ड इनटू कॉन्सेंसस, या उनके आपस में बात हुई होगी कि इसका सोल्यूशन ये हो सकता है, तो उसी के टर्म्स में उन्होंने लॉ बना दिया. Because ultimately whosoever is making the law, that is also a person, right. Our representatives in the parliament or in the state legislature for that matter, one may look at various legislations or statutes provided for by legislature, and if there is a lacune then one may look at the decision of domestic courts. Lacune means if there is a loophole, कुछ कमी रह गई या कुछ गलत बना दिया, जैसे कहते हैं कि पॉलिसी एरर हो गया, लेजिस्लेटिव एरर हो गया, बिकॉज अगेन दे आर ऑल्सो एट द एंड ऑफ द डे दे आर ऑल्सो पीपल, राइट, ह्यूमन बींग्स. अ ह्यूमन बींग इज सस्पेक्टेबल टू एरर्स, राइट. सो उनसे भी कोई गलती हो सकती है, तो अगर वो गलती हो गई, लेकुना हो गया, जिसका कोई गलत फ़ायदा उठा सकता है, या इट मे रन टू मिस यूज बाय सम पीपल. सो इन दोज सिचुएशंस courts will interpret that law. Court is another organ of government which cannot encroach upon the jurisdiction or it cannot perform the functions which is to be performed by the other organ of government, that is legislature. तो वो law तो नहीं बना पाएगा कि हमने law का provision बना के एकदम law को ठीक कर दिया. That courts cannot do. सो व्हाट दे कैन डू इज़ कि वो रिक्वेस्ट कर सकते हैं, रिकमेंड कर सकते हैं लेजिस्लेचर को कि आप इसको सही करिए, या फिर अगर कोई इंटरप्रिटेशन के टाइम पे लेकुना आया है तो वो उसको ठीक कर सकते हैं. कोई लॉ कॉन्स्टिट्यूशन के बेसिक स्ट्रक्चर या प्रिंसिपल्स के अगेंस्ट गया, उसको अनकॉन्स्टिट्यूशनल, नल एंड वॉइड डिक्लेयर करके दैट कैन बी रिपील्ड. सो ये सारी चीज़ें कोर्ट कर सकती है इन रेफरेंस टू द लैकुना इन द स्टैट्यूट. But it is not so easy to pinpoint the sources of international law. Yet, the most authoritative source of international law is Article 38(1) of Statute of International Court of Justice, which provides that when a court deals with disputes relating to international law, it shall apply the following. The court whose function is to decide in accordance with international law such disputes as are submitted to it, that means whichever dispute has come to it, submitted to it means जो भी dispute उसके पास आया है और उसने उस कोर्ट को उस कोर्ट ने उस dispute को admit भी किया है that okay, I am having the jurisdiction and I will allow this suit or dispute to be heard in my jurisdiction, in my court, right. It shall apply international conventions, general or particular, establishing rules expressly recognized by contesting states, international custom as an evidence of general practice accepted by law. Custom is anything which was in prevalent through generations for a very long period of time, and since it ran through that long period of time, it developed the status of law, right. So any such custom which was prevalent in the international domain through long generations, that is also something which is accepted by law. अगर उसको law का status मिल गया है, so that also has to be taken into consideration. शैल अप्लाई का मतलब ये है wherever shall has come that means it is mandatory. ओके, अप्लाई हेयर डज नॉट मीन कि ये कंपल्सरली सारे ही अप्लाई करने. हो सकता है उस पर्टिकुलर सिचुएशन के लिए कोई कस्टम नहीं हो तो फिर कस्टम को नहीं अप्लाई. कोई कस्टम ज़बरदस्ती अप्लाई नहीं कर देंगे in a situation where it is otherwise not applicable. Okay, so wherever whatever provisions are being attracted वो सारे अप्लाई करना ज़रूरी है. ठीक है, so that means these are all the checklists which the court has to see that whether such and such provision are being applied or not. Okay, and international convention is what? Something which many countries have agreed into by consensus that okay, we are agreeing on this particular issue which is a concern nowadays, and that convention is basically for what? It establishes rules for something, for some subject or the other. कुछ rules ही तो establish करते हैं ना उस convention में. जैसे फॉर इन्वायरमेंट कंट्रोल जो क्योटो प्रोटोकॉल है या पेरिस प्रोटोकॉल है उसमें क्या इस्टेब्लिश हुआ कि हम ग्रीन हाउस इफेक्ट को कम करेंगे, एमिशंस कम करेंगे ग्रीन हाउस गैसेस का. सो दैट इज़ द रूल विच इज सेट आउट अमंगस्ट द वर्ल्ड. कंटेस्टिंग स्टेट्स मीन्स विच आर द पार्ट ऑफ दैट कन्वेंशन. जनरल प्रिंसिपल्स ऑफ लॉ रिकग्नाइज्ड बाय civilized nations subject to provisions of Article 59, judicial decisions, teachings of most highly qualified publicists of various nations as a subsidiary means for determination of rules of law. Subsidiary means it is not the main method of determination of rules of law, but अगर प्राइमरी या मेन रूल्स नहीं है, मेन मेथड्स नहीं है, तो आप इस लॉ पर आ सकते हो. ठीक है, सब्सिडरी का मतलब है जब प्राइमरी चीज़ अवेलेबल ना हो तो हम इसको काम में लाएंगे. हेयर मीन्स रेफर्स टू द मेथड. डिटर्मिनेशन का मतलब है डिसाइड करना. ठीक है, जनरल प्रिंसिपल्स ऑफ लॉ मीन्स वॉट एवर द जनरल प्रिंसिपल्स आर इन द इंटरनेशनल कम्युनिटी की पीस होनी चाहिए, राइट, कोऑपरेशन होना चाहिए, ये सब जनरल प्रिंसिपल्स हैं. इजंट इट समथिंग लाइक दैट ओनली विच आर रिकग्नाइज्ड बाय द सिविलाइज्ड नेशंस and they are subject to what? Article 59, judicial decisions, that is again precedents and teachings of highly qualified publicists of various nations, because we are not concerned with a particular nation here. So जो भी well versed या बहुत ज़्यादा experienced qualified publicist होंगे उनके teachings या उनके कुछ sayings को भी हम consider कर सकते हैं. अब सोचो, अगर हम किसी की कही हुई बात को कंसीडर कर रहे हैं तो मतलब वो सब्सिडरी मीन्स ही तो होगा ना. वी कैन नॉट कंसीडर द सेइंग्स और द मेंटालिटी वट एवर अ पर्सन हैज़ सेड. दैट शोज़ कि वो क्या सोचता है उस पर्टिकुलर सिचुएशन के बारे में, उसका परसेप्शन क्या है, राइट. तो हम किसी के परसेप्शन को तभी इम्पोर्टेंस देंगे जब हमारे पास प्राइमरी रूल्स नहीं हैं. सो बाय इटसेल्फ इट शोज़, इट कन्वेज, और it can refer to the subsidiary means, right? Okay. Article 38(1) divides the sources of international law into primary and secondary. Primary sources which the court will consider include conventions, treaties, customary law and general principles recognized by civilized nations. These are the primary sources. Judicial decisions, teachings are referred to as secondary sources. Okay, then the third source are general principles of law recognized by civilized nations. General principles are used primarily to fill gaps when treaties or customary law do not provide a rule of decision. That means they do not provide a rule by which we can solve a particular dispute. The rule of decision means they do not provide a method or the rule. जैसे कॉन्ट्रैक्ट का डिस्प्यूट आया और सोचो कि इंडिया में इंडियन कॉन्ट्रैक्ट एक्ट होता ही नहीं. ठीक है, सो दैट मीन्स लॉ टू सॉल्व दैट डिस्प्यूट या रूल टू सॉल्व दैट डिस्प्यूट है ही नहीं. ठीक है, सो तब हम कस्टम्स पर आते. फाइन, दैट इज़ व्हाट इट मीन्स. फिल गैप्स मीन्स व्हेन द ट्रीटीज और कस्टमरी लॉज आर नॉट इन प्लेस फॉर अ पर्टिकुलर सब्जेक्ट, तो फिर उनके एब्सेंस से जो गैप, जो वैक्यूम क्रिएट हुआ है उसको फिल तो करना पड़ेगा ना, क्योंकि जो डिस्प्यूट इन हैंड है, जो कोर्ट में आया है, उसको सॉल्व तो करना है। उसको ऐसे तो नहीं छोड़ सकते कि भाई लॉ नहीं है तो तुम अभी रुक जाओ, हम मैटर स्टे कर देते हैं, जब लॉ बनेगा तब देखा जाएगा, या क्योंकि इस मैटर पे लॉ नहीं है तो आई एम रिजेक्टिंग द डिस्प्यूट, जो हालत है वैसी रहेगी, अब मैं कुछ नहीं कर सकता इस पर, राइट। दिस अप्रोच कैन नॉट बी टेकन अप बाय एनी कोर्ट, वेदर इट इज़ डोमेस्टिक और इंटरनेशनल, right? It will not be said to serve justice, right? So the gaps are to be filled. They could be general principles of justice, natural law, analogies to private law, principles of comparative law, or general conceptions. Okay, justice करना है हमें, that whatever आप कोई भी रास्ता निकालो उस डिस्प्यूट को रिजॉल्व करने का, बट वो रास्ता ऐसा होना चाहिए दैट इट लुक्स कि हाँ, एंड इन एक्चुअल ऑल्सो, नॉट ओनली बाय लुकिंग ऑन इट, बट इन एक्चुअल ऑल्सो दैट वे और दैट एडजुडिकेशन हैज़ रियली डन जस्टिस टू बोथ द पार्टीज कंसर्न्ड, ओके। एंड दे आर जजेस, qualified people, right? They may use their rationale and human logics to find a way to the dispute. The general principles are also found in textbooks, general surveys, manuals, treatises, encyclopedias. It has been suggested by scholars that as new treaties, customary law developed to address areas of international concern not previously covered, the significance of general principles will fade as these gaps are filled. अगर उस point पर through time international conventions and treaties are being entered into, that means primary sources of international law would be in existence for those subjects, तो फिर हमें secondary पे जाने की ज़रूरत नहीं पड़ेगी, right? So that means for those general principles scope that will decrease with time because we will be having primary sources by then. Article 38(1) is technically limited in application to ICJ. ICJ rules है, so it is limited to ICJ. Since function of court is to decide disputes in accordance with international law and all members of UN are ipso facto, means by itself members, it is widely accepted that this is considered as enumerating the general norm on sources of international law. So whosoever is member of the United Nations by itself, by the virtue of being members of UN, they are automatically said to be the members of this ICJ rules also. Fine. Then the meaning of ipso facto is given, which is what I have said right now. ICJ do not suggest any hierarchy. They are generally applied in the following order. That order we will be doing in the next video. Thank you so much.